Ms. Whitaker had full vision in one eye, but very limited vision in the other. Dr. Rogers told her of an operation that could restore her sight. What he didn't tell her was that there was a chance of a phenomenon known as sympathetic ophthalmia. In English, what that means is that if things went wrong, there was a slight chance she could actually lose vision in the other eye too. Ms. Whitaker agreed to the surgery, and the worst happened. There was no improvement to her bad eye, and she lost all of the vision in what had been her good eye. She sued. Dr. Rogers relied on an Old English principle called the Bolam principle, which basically said that he was only required to provide her with the information that would be considered reasonable by a responsible body of medical opinion. In other words, because most doctors wouldn't have told her about the issue, Dr. Rogers was not negligent. The High Court found that the Bolam principle didn't apply here in Australia because there was a higher principle in Australian law, the principle that a person is entitled to choose the risks that they take, especially where those risks may have a massive impact on their life. The majority judges said the law should recognise that a doctor has a duty to warn a patient of a material risk inherent in a proposed treatment. A risk is material if, in the circumstances of the particular case, a reasonable person in the patient's position, if warned of the risk, would be likely to attach significance to it. So the test applied by the High Court was not a question about what most doctors would have done, but rather the test was what most patients would have wanted or needed. Since this case was decided in 1992, parliaments around Australia have passed the Civil Liability Acts. They preserved the principle in Rogers and Whitaker. Section 21 of the Queensland Civil Liability Act says that doctors have to provide information that a reasonable person in the patient's position would, in the circumstances, require to enable the person to make a reasonably informed decision about whether to undergo the treatment or follow the advice. They also have to provide information which the patient specifically requests. So the duty is still measured by the needs of the patient and not by the usual practices of doctors.